Jan, thanks so much for coming in today. How have you been feeling? Have there been any changes in your symptoms?
No, I'm still in pain, but I'm good. I'm good.
Good. I'm glad to hear that. I'm so glad that we have the opportunity to talk today because there have been some recent developments in your case that it's really important for us to talk about and to understand going forward. So we have quite a bit of ground to cover, but please feel free to stop me if you have any questions or if anything is unclear.
Okay.
So I spoke with Harvest Plenty's attorney yesterday, and he indicated that he is likely going to file something called a motion for summary judgment, which would be a pretty significant challenge to our case.
What is that?
That's a document that Harvest Plenty's attorney will prepare and submit to a judge, in which he's going to outline arguments based on all of the facts that we've gathered and all of that information that we've gathered from the depositions with you and with Harvest Plenty's attorneys and what we know about what happened the day that you were hurt. And he's going to ask a judge, argue to a judge really, that all of those facts taken together mean that there is not a legal basis for the relief that we're seeking. And in this case, the relief we're seeking is a monetary award.
What about ours?
Well, that's a good question. So if Harvest Plenty's attorney files that document, we actually will have an opportunity to file a document as well, where we'll make arguments that say a judge should not find that. Essentially, that the judge should find that there is a legal basis for the award that we're seeking. So when a judge reviews those documents, he or she is going to apply what's called the open and obvious doctrine, which is a legal concept here in Ohio that in cases like yours where somebody gets hurt on another person's property, the law says that if what caused that injury is noticeable or should have been noticeable to that person, then the property owner is actually not responsible for that person's injuries. Does that make sense?
So I should have seen that? Like, I shouldn't be reading labels, I should be watching the floor?
Well, the open and obvious doctrine says that if what caused the harm is obvious and was in plain view, then it's not Harvest Plenty's responsibility to compensate you. And I'm not saying that what happened was your fault. But under the law, a judge could find that Harvest Plenty was not responsible for it and does not need to compensate you for it.
That's not fair.
And I know that it feels that way now. But if we look at, for instance, you work in the restaurant, right? If we look at if somebody were to get hurt in the restaurant where you work, and you think that the thing that they got hurt on was obvious, you might want the law in that case to not hold the restaurant responsible because the thing that caused the person harm was noticeable to them. And so that's why the law is that way. I'm not saying we have to feel good about it, but that's why it is that way. Does that make sense?
It does, but it was their spill and their story.
Right. And we're going to argue that it was their responsibility.
Our side.
Yes. Yeah. We're going to argue our side. In one of those documents that we file with the court, we'll state all the reasons that it was Harvest Plenty's responsibility and that what caused your harm was not obvious. So what I'm going to argue in that document, or what I would argue in that document, is that Harvest Plenty was not maintaining their store the way they should, and that they knew that. That there was food in places, and you mentioned that things were dirty. Is that right? Yeah.
Yes.
And that there had been actually several spills in the previous days leading up to your accident. And so those are the things that I will argue to say that what caused your harm was not noticeable and should not fall under that open and obvious doctrine.
Okay.
But Harvest Plenty is also going to make arguments. And they're going to argue to the judge that the spill that caused your injuries was an orange juice on a white floor, so it was noticeable, and that there was good lighting in the store, and that there was a loud commotion when the spill happened. They have 2 witnesses that are willing or have already testified that they heard the big commotion, that when the child screamed and when his mom was yelling at him and when that spill happened, that it was very noticeable. And they'll likely argue that you were focused on labels rather than on your surroundings. And so for those reasons, those arguments weigh against our arguments. And based on the way that similar cases have come out in Ohio, which the judge is bound to look at and to follow, that the open and obvious doctrine would apply and that summary judgment would be appropriate.
What does that mean?
Well, that means that the judge would likely dismiss the case based on those facts. And I think that it's very likely, in fact, that a judge would do that. In fact, I think it's probably about a 70% chance.
Really?
Mm-hmm.
So there's nothing else we can do?
No, not necessarily. We do have some options still. But do you have any questions about any of that information? Anything to do with?
So you think that a trial would not be in our best interest?
That's correct. I don't think a trial would be in our best interest because of the probability of summary judgment. I think that there are also important considerations, and people often have questions about timing and cost considerations about things like trials. So do you have questions?
Yes, I hadn't thought of that at all. I'm going to have doctor bills.
Mm-hmm.
I'm probably going to have deductibles, and I have rent.
Mm-hmm. Right. And so there would be costs associated with trial and summary judgment. So there would certainly be costs associated with preparing for summary judgment, preparing those documents that I talked about, like a brief.
Right. You have
Mm-hmm.
costs. Right.
Right. And that would probably take about 3 months to put together those briefs and for those to be filed with the judge. And then the judge would have about 6 to 9 months to review that information and make a decision.
Oh, okay. I do have some savings, but that's a long time.
It can be a long time.
What else is there?
Well, we had talked previously about settlements.
Oh, yes, we did.
Yeah, so I think that the opportunity for a settlement is good. And in fact, I talked with Harvest Plenty's counsel very briefly about the opportunity for settlement, and he indicated that he thought his clients would be open to a settlement agreement.
Oh, well, that's good.
Yeah, I think so. And so,
So what do we do from here then?
well, I would talk with Harvest Plenty's attorney about a settlement agreement, and we would discuss the terms of an agreement that would be agreeable to both us, and then Harvest Plenty, of course, would have terms that they would prefer or like, and then we would have to come to an agreement between the both of us.
So a trial is not going to be to our benefit, and we've talked about a settlement, We've actually talked about it before. So I think I talked about $250,000. I think that's a good number.
Well, that amount really was really the upper limit of what we had talked about before, and I think that it's fairly unlikely. Actually, I think it's very unlikely that Harvest Plenty would agree to a number that high. I think, based on my past experience with Harvest Plenty's attorney, that a range between $40,000 and $50,000 is more likely, and I think that that's an offer that we could get.
That's not enough. That I just lost $200,000 in without negotiation.
I know that it feels like you've lost money, but that amount of money was never on the table. It was not an offer. So really, you haven't lost anything. But I do think it's important to remember that the offer that is more likely would be more than enough to cover the costs that you've incurred because of this injury. It would cover your lost wages, it would cover the expenses of your surgery and your recovery, your physical therapy bills, and all of those associated costs. So let's not think about it as a loss, but let's think about it as an offer that we could gain that would help you.
$40,000 or $50,000. That's nothing to them. That's half an hour's worth. That's a big company. I'm a small person, but there's other people that can be hurt. That aisle is a mess. It's got food in it. You can slip on stuff. There's all kinds of crowding there. Somebody's gonna get hurt badly. More worse than I am. At $40,000 or $50,000, that's not gonna make anybody pay attention. That's not gonna be a priority to them.
So what I think I'm hearing you say is that the priority here is that Harvest Plenty needs to change what they're doing, change how they're maintaining their store.
Yes.
Okay, so that's really helpful for me to understand that that's the priority, and so perhaps let's be thinking about that as the priority rather than the amount of a settlement agreement. Because if we can really show Harvest Plenty that they need to be paying attention and they need to be cleaning up their act, then we can help make sure this doesn't happen to someone else.
Yes. Can we do that?
We can certainly try. That's certainly something that I can communicate to Harvest Plenty's attorney, and perhaps we can even communicate it directly to Harvest Plenty when I talk to him about a settlement agreement. And if that's the major priority, then that's certainly something I can emphasize.
So it can be part of it.
We can certainly try that, yes. And would that reach your goals for this?
Yes. If I could get my medical, my other expenses, and I could help someone not be hurt in the future, I would be happy with that.
Okay, good. So I'll give Harvest Plenty's attorney a call later this afternoon and see about that amount and communicate to him about our concerns, and then I will give you a call back.
And you'll let me know.
I will.
Thank you so much.